of the handout today. I would be happy to discuss any case or issue you may have with regard to the Hague. John's agreed to and been kind enough to do the overview and intro. We're going to limit him to 15 minutes. Can somebody bash him over the head if he takes more?
All right. We hear about it, the Hague Convention. We hear about it all the time. And actually, there's no one Hague Convention. There are 39 of them. The Hague Conventions on private and international law came into being really in the last century as a result of the Industrial Revolution more than anything else. As you know, Europe has a lot of different jurisdictions. Some of them small, some of them pretty good size. In commercial disputes, whenever there's money, there's a fight. And they attempted to blend various laws or various legal traditions into one so they could better facilitate commerce. And as they went along, they added to it. We have, we've got conventions for the sales of goods, the succession to decedents' estates, divorce now, and child abduction. Now we're most familiar, or we hear most of the time about the Hague Convention on the civil aspects of international child abduction. That is different than what we're going to talk about today. We're not going to talk about that at all. I do want to touch on one aspect of it very briefly. That is to distinguish what we're talking about today. We're talking about in personam jurisdiction. That's all we're talking about. Because we're talking about service here of civil or commercial or judicial and extrajudicial documents. That means in personam only. The Hague Convention on the civil aspects of international child abduction deals with subject matter jurisdiction, whether the court can act at all. Now, since we have to deal with, and I put it on the board, we have to deal with the Hague Convention from time to time. This is a tremendous resource right there on the board. That'll get you all the Hague Conventions. And the Hague Convention on the service abroad of judicial and extrajudicial documents is a skinny thing. It's only 10 pages. It's easy read. It's not hard. None of this is hard today. We know that the Hague Convention at this time, and I say at this time, applies to dependency actions. And Ernesto is going to talk to you a little bit about the case law on that. I'm not going to get too far into it, but there seems to be some judicial antipathy towards the Hague Convention as it applies to dependency actions. Nevertheless, I would point out this Hague Convention can be your best friend. Because quite often here, we have the mother, and the father's in Mexico, Guatemala, or it could be somewhere else. And we have to get in personam jurisdiction on her. Particularly if she gives you enough information whether they could find him a presumed father. Now, under the Hague Convention, service of process is pretty much deemed effectuated at the passage of 6 months. That's a good chunk of time for us in the dependency world. And if you've got a druggy mother who needs to get cleaned up, that 6 months can be a gift. Use it as a sword. There, we will talk a bit about the requirements. And the requirements, you want me to go? Yeah, okay, fine. The requirements are simple. You file a petition, usually there's a detention report, and then there's notice of the hearing. Those, if for instance you were going to Mexico, have to be served on a central authority or some other designated reception point for the receiving state. Okay? And that's important to keep in mind because some receiving states will allow you to serve a consular official. We don't. You'll see that there are exceptions and our reservations to the treaty. And by the way, folks, this is a treaty ratified by the Senate. As such, it has constitutional stature. And that's important for you to be able to argue. Under the Supremacy Clause, it's supreme. It overrides state constitutional law, state decisional law, and state statutory law. Flat out. It rules. So you want to keep that in mind, because if you have to argue it, and we hear bench officers all the time telling us, I'm here to protect children, I'm going to go ahead. No, wait. Make your objection. You want to make the objection because that's going to preserve issues for any appellate action, and may even get you, if you're in front of a referee, a rehearing, depending on who the judge is who reads it. Some judges are familiar with this, some aren't. The documents usually are served in duplicate, and I told Ellen I will give her these, and I'm going to get them out. They are, you have to translate the documents being served in these forms. Has to be translated into the native language or a designated language by the receiving state. That's important because there's an official language for some states, and other states have a bunch of languages in it. Gee, I don't know how many languages are spoken in Mexico. It's not just Spanish. Now, Mexico probably uses Spanish as its default language, but they could tell you to translate them for somebody in the Yucatan, if they wish, into a Mayan dialect. And if that's their requirement, we got to do it. That's also something to keep in mind, because you'd think that we have interpreters for every language known to man or God in this state, and we don't. I did a Mongolian adoption a couple of years ago, and you need documents translated. I went to the Judicial Council. They listen. We have Mongolian interpreters until you call them, and they don't. And then you call UCLA, USC, Berkeley, call them all, and we have people who study Mongolian history and language, and they don't feel comfortable translating. So I had to send the documents to Ulaanbaatar, have them translated, not tell them that I'm adopting out a 15-year-old citizen of theirs, and they send it back because they want the girls. It's a very, very underpopulated country for an Asian country. They would grab her back. So Henning did the adoption, and come get her if you can. Okay? The bottom line is, we may not be able to translate it. That was the mentioned service. That gives you more time. There are actual specific, and I've given them to Ellen, documents that accompany the documents that you're serving. And you get those off the net, right here.
I'll scan these and send them in an email.
Take a look at them. They're either filled out in the language that the receiving state requests, or French or English. Now, English isn't a problem for us, but it may be for a receiving state, and they may prefer it in French. Well, DCFS, you're given notice, do it. They may also request it in their particular language. Please look at that. Make sure they hit the central authority. The central authorities for all nation states who've signed this is right there. All you have to do is click, you can get right to it. Then look at the reservations, which are attached, and we got them, and there are a lot of them. That's why this thing's 83 pages, and now I misplaced, oh, here it is. You got all these reservations. Please pay attention to those reservations that are in the back, because that will tell you how each individual state varies slightly the Hague Convention service requirements and who to serve it on very often. Here, the United States takes out consular officials because under federal law, you can't serve process on a consular officer for any person in the United States. It has to come to our central authority.
I was just thinking about when you told us about how you have to make the objection to preserve the right. Can you tell us what language we should use?
Yes, service is improper.
Okay.
See, if we're going to go to disposition, They could probably do the adjudication with your client here, but disposition's a little tougher. Because if the person isn't noticed, how do you remove from the father? You don't have in personam jurisdiction to order the removal, if you know where he's at. Obviously, if he's an unknown father, we do a due diligence and call it a day. Now, remember, they'll try and do a due diligence, and they will check the LA County Registrar Recorder, the DMV, the Post Office, the CYA, prison system, and the guy lives in Guatemala. They'll try it. No. They have to actually go and go through the consulate, the central authority there. Other problems are we don't translate it, so they kick it back. Or the translation is unreadable. Sometimes they kick it back. They don't know where the guy is. The address doesn't exist. That may give the court some room to get at disposition because his whereabouts are unknown. And then they'll just go under a G and be done with you.
So let's say that we get appointed for a parent and there's a Hague issue. Until notice is proper, should we just be making a special appearance then?
Okay, we're going to talk about that, and Ernesto's really going to talk about it. I will talk about it very, very briefly here, because that looms very large in the case law. First off, if the mother's here, because it's usually the mother that we get, and the father is in another state, nation state, the first question you should ask, not that you're going to do anything, but you want to know, so you're not blindsided, is there an order of a court in that state determining child custody and visitation? That's what you ask of your client. Now, relax, 99.9% of them, there's no such order. And if you forget to ask, the odds are with you that it isn't going to be a problem. But you want to know, and you want to know for a reason, because if there could be, your client may be looking at you, and I did a guardianship for Colombian National a few years ago. The courts there are incredibly corrupt. They're just horribly corrupt. And my client did not want those courts involved at all. And I had a very sympathetic commissioner, and the guardianship got signed. She's here. Let them come get her if they can. Okay? But you want to know, because if, in fact, the consulate here, you serve the central authority, comes back and says, hey, we got a adjudication of child custody. She left the Ecuador or Mexico or wherever and didn't receive our permission. Now, you're no longer in the service of process. You just defaulted in to an international child abduction case. And that is where the subject matter jurisdiction comes in. And that we'd have to talk about separately. The subject matter jurisdiction can get a little complicated. But it's just like and the UCCJEA kicks in at that point too. We don't want to get into that because, again, that's subject matter jurisdiction thing. What you need to do is take a look at the Hague Convention. Again, download it. It's 10 easy pages to read. It's not hard. You want to look and see first, did they use the forms? Are they filled out in the correct language? Has there been a translation of the petition? Has it been served in duplicate unless the receiving state says we only need one? They usually require two. Take a look at it, when it was served, who it was served on. You've got all your central authorities right there, right at your fingertips. If you find the service is bad, and mom's here, father's in Mexico, Guatemala, or France, doesn't matter, then say, look, we don't have service. Slow it down. Slow it down. And particularly slow it down if they release the kid to your client. What do you care at that point? Just slow it down. Because she'll finish her programs and they can dismiss it. They can get her out of here. That would be, I better not go too much longer because I have a feeling I'm going to get hit from here. Understand once. Service is going to effectuate it pursuant to the Hague Convention. That's it. Don't look for it anywhere else. So if you get it at jurisdiction dispo, you're not going to have to do it for review hearings, the 2-6, any of them. It's once only. The other last thing, and I'm going to let Mr. Ray go here, is I want you to avoid any potential IAC claims. And that is where we come here. Ernesto is going to speak very clearly as to the appellate court's views of the Hague Convention. You can make your special appearance. The problem that you have is you're an attorney, you work in this area, and since your client isn't here, very often the court takes out a long knife and starts really carving on your client. And the natural instinct at that point is start objecting and start screaming. You can't do any of it. You have to let your client take the hit. You are making a special appearance. You're objecting to lack of proper service. And it's important because they can't terminate his parental rights. And if they can't terminate his parental rights, they can't terminate your clients. The disposition, it's touchy whether they can really do a disposition and bifurcate it. They'll try it. Would a court of appeal allow it? Probably in this district at least. Some other districts maybe not. But you can't get to the ultimate guardianship or adoption of your client's children if he's not noticed, and we know where he's at if we're not giving proper notice, because they have no in personam jurisdiction over him. So keep that in mind. I'm going to let, and by the way, if you blow that, then the parent does show up. He does get whacked, or she gets whacked. Then appellate counsel might be looking at it saying, why did counsel do what he or she did? I wouldn't worry about civil liability particularly, because most of these people have no concept of what it is. And then you've got your IAC claim, and who wants that? That's no fun to write, and it's no fun to be the subject of. And as I mentioned about 2 years ago, when we did a thing on IAC here, there, but for the grace of God, don't any of us, including me. You've gone through all of my cases. I'll bet you could find an IAC or two. We're all human. But let's not make it. Let's not make it easy for anybody. So I'm going to let Mr. Ray.
Thank you. All right, well, folks, I want to talk a little bit about case law, and I want to analogize the Hague Service Convention to ICWA in this sense. When ICWA first started, the appellate courts would give you a reversal of disposition at the 2-6 and practically with nothing. And in 2003, you could get an ICWA reversal. The problem was, what's the point? 99.9% of the time, you're not going to get anybody that's Native American. So it was a kind of a hollow victory. Unlike the hollow victory, the Hague Convention gives you an excellent opportunity. Say your firm requires you to accept a case at detention simply because the mom who is there says, you know, dad is in Guadalajara and this is his address. You have to make the appointment. So it's not like you have a whole lot of choice. The question then is what you do and how you do it afterward. You have to look at a positive thing. The positive thing is that you've got 6 months, very likely a year, of blindsiding the department, basically, because my experience with the Hague is that the department is about as good at serving Hague notice as they are ICWA notice. In other words, they don't always get it right, and that's pretty tongue-in-cheek. So if they don't get it right, it's 6 months if they get it perfectly. If they don't, it's a year. So you've just bought the other parent a chance to get the kids back, assuming that other parent is willing to. So I think that's a rather interesting spin on it, and that's one I'd like for you to consider. You know, the IAC that John talked about is really important to us on appeal, because when we get appointed, about all we have is either a writ of habeas corpus or IAC. None of us want to do that, because so we've all been in the same position. I mean, I was doing the same stuff you guys are doing too long. So I would suggest that if you take the case at a petition filing, dad's never been in the country or wherever, he's not here, you have to make sure that you don't do what a panel attorney did up in the 5th floor with Judge Henning. And that's the first case I want to talk to you about. The full case is in your material, so you don't, have to do it. Vanessa Hugh. That's the most recent Hague Conventions case out of the 2nd Appellate District, Division 7. Justice Perlis, who used to be Judge Perlis in Debbie Andrews' court, 420, back before Bob Sandoval, but then I digress. Anyway, he's the one that decided or wrote the opinion on this case, and I know it very well because I was the appellate attorney on it. The facts on it are much like the facts that we get on typical cases here. The dad was not very sympathetic. He was living in Pico Rivera. His wife got ticked at him beating her up on a regular basis, so she took the 2 kids, moved in with her mom and dad, his in-laws. He got ticked, so he went at night with a gun, a pistol, and was brandishing it, put it in between her eyes, and it didn't go off. So he did the next best thing. He tied up his in-laws, took them to the living room, took the mother to the living room and raped her. Then that wasn't enough. He drove from their house back to Pico, and then in front of his house there was cops, so he kept on going to Guadalajara. Sent the mother back a few years later. If you tell everybody that you were here voluntarily and that everything was hunky-dory, you may see your son again. I'm going to send you back to clear my name. She went to the FBI and made a big effort to get her kid back, and eventually got it back, found the love of her life, remarried, and wanted to terminate Dad's parental rights over Vanessa so that he could adopt her. The same operative law, the same identical operative law. The problem, and why I took the time to give you the facts as I wrote them, as they were on the record, is because sometimes you get really crappy clients. I mean, really, really hard to find anything. He was in maximum prison because he had escaped out of prison and had done some heinous crimes in Mexico, and basically not a whole lot going for him other than one thing. Everybody, the judge and everyone knew he was incarcerated in a maximum security prison just outside Brownsville, Texas, on that side of the border. And he was served in accordance with what we call Section 291E, which is certified return receipt mail attached to petition for adoption and the citation translated into the Spanish language, which was mailed to his place of incarceration, return receipt requested, or the international equivalent on file. Judge says, this seems good notice, or sort of notice, let me appoint counsel. Counsel is appointed. Counsel says, well, I have to get in touch with my client. He gets in touch with his client. The client, the dad, writes to the court and says, hey, you know, Mom's making all this stuff up. I'm actually Ozzy and Harriet kind of marriage. This was wonderful. We got no problem. So the court finds that since he had appointed counsel asked for a continuance, said, look, my client wants a continuance for me to go talk with him in person because this stuff can't be handled over the phone. They don't have enough facilities in the Mexican max security prison. Judge says, this case has been going on for eons. I'm not going to give you a continuance. And he terminated parental rights. Dad appealed, a proper appeal. Court of Appeal, Justice Perlis said two things. The first one is very good because it is the state of the law in this appellate district. There is a law review article which I happened to run across through the internet, and the law review article indicates that Mexico, John just talked about reservations. I, being Native American, am not trying to imply anything about reservations, but Mexico has no reservations. Each country that signs this gets to make their own reservations or not? They said, no, nothing other than central authority. I won't get into letters rogatory and other exceptional circumstances because they don't really apply here. We don't have that time. But what I am saying is that if that is what Mexico wants, the Court of Appeal in this district has said that is the only way. No first-class mail, no nonsense. It's got to be that way. And I have done quite a few of these unique forms for Mexico. I'll just redact the names and you can have one. The point is that your job is not to do the Hague notice. You should not be doing that. Because the moment you take a general appearance, or one is implied for you, which is what happened in Vanessa. In Vanessa, I went to oral argument. I said, I'm really thrilled that the court has agreed with the law review article as a matter of law now. The convention requires for Mexico central authority. That's it. No other, it's not complicated. They said, yes, Mr. Ray, but he asked for a continuance. That's a general appearance, don't you know? And they affirmed him based on counsel asking for a continuance. So what I'm saying is there is waiver, and there is forfeiture, and then there is the court. The court will imply, as long as there is any evidence, a scintilla, they can imply it. It was implied there. The attorney there did not say, I'm making a special appearance in order to contact my client. In the 5th District, I won't mention the parties, but I write for other divisions, and one of them has, one of the judges in dependency court has told the county to serve Hague notice on appointed counsel. So they just appoint an attorney, piggyback notice to under the Hague to the representative, and hey, we don't need no stinking convention. That's the way it is. I don't think that's going to happen here, but my caution to you is, if you take a case, make sure you don't argue any of the merits whatsoever, even the request for a continuance. I am appearing specially for the mother, father, whoever you're appointed for, whichever you're appointed for, and that's it. I have not been able to contact my client and speak no further, no matter what is asked of you, because then you have given, you've in effect given the Court of Appeal an opportunity to apply a finding.
And what if the court then goes ahead and terminates your client's objection? Are you allowed to say, please note my objection, I'm still specially appearing, or what do you do?
If you have made a special appearance, you don't have a right to argue. An objection as to the merits is an objection as to the merits. You just wait your client's appearance the next day on a case that you least expected. I had a terrible case most of you have heard of, Lance Helms. The guy was the least person on this planet I thought would sue. So his grandmother, his mother, sued. The last person on earth. A heroin addict in jail, not really someone you would expect. So I would say no. I would just say, please note, I am only specially appearing. I'm specially appearing for Mr. And I have had no contact.
And then the right
But
to
Marpet will do
terminate.
what Marpet will do anyway.
But the rights are terminated,
changed,
then you
sorry.
write to your client and have him send in the notice of appeal in his name.
Well, if you have had no contact with your client, how are you going to do that? You ask to be relieved for want of a client.
When you
I
do
wish to
that,
be relieved before he impanels the 2-6, Your Honor, before the court impanels the hearing, or before you start opening your mouth. Relieve me. I've had no contact. Please relieve me and set me free.
Okay, so I'm specially appearing, I've had no contact with my client, please relieve me.
Right. And I wouldn't wait till the day of the
Deny.
hearing. I would do it a week. That's what I
But
violated
we
on my
don't,
motion.
that's not the real world. We're
Yes, the
appointed
real
like
world
5
is-
minutes before lunch. Here, take this, you gotta get out of here,
That's
I got
true.
golf days.
That's true. Look, you can do it one of two ways. You can have a canned motion to withdraw. If you don't have one, we can give one to you. Ellen, any of you, just file a motion to withdraw like you would a 388 at the eve of a 2-6, right there on the spot.
Can you say I'm declining to take this? And so,
You can decline an appointment, but then you've got a problem with the head of your organization, don't you?
well, that's, if
Yeah,
I haven't
I mean,
been
you know,
trained
you're
on
damn-
what to
you know,
do,
you
I'm
can't.
doing the best I can.
The purpose of ladle is to represent parents, and the purpose of the appointment is if you have contact information, it is that person's right to know, and they're appointing you to try to get a hold of him. They're not appointing you to actually get a hold of him because that requires a crystal ball.
They're appointing you to stand in, be a placeholder, so they can do what they want, and you're left holding
A bag.
malpractice bag.
That's
Linda, you can always object to the lack of proper notice. That you can always do. Always object to that. That you have the perfect right to object to. The merits of the action, you can't. Now, the problem is, and I think just to make it clear, if you make that general appearance, your duty as an attorney, particularly if you have contact with your client, is to communicate with your client. That can be difficult because your client may be speaking a language that is difficult to find a translator for. Your letter, you can send it in English, but I don't think that meets the requirements of the state bar rules. Because he's not going to be, or she is not going to be able to read it. And they may have no way of reading it. So you've got to go out and find someone who can translate into a line language, because you don't care about the official language, you've actually got to communicate with that client. And good luck finding one. It's not easy. So you don't want to waive the objection to notice, because if you do that, it all falls on you. And that's what we don't want to do. We don't want it on us. That's why you have a department that has a budget of close to $1 billion, I think, with all the federal monies. You know, they go out and hire somebody to do it. Why should you do it?
You have a question?
Just real quickly, I'm still trying to get the steps as to the best practices. So in the 2-6 scenario, if the court in its rush is doing that to us, of course we're going to make a special appearance, and that's all we'll say. But we'll make a special appearance because we're objecting to notice. I get that.
But by
Now,
the time of the
hang
2-6.
Hang on 1 second. The court denies that. My question is in tactic, is it better, and I'm just asking this, at that point to ask to be relieved, or is it better for the client to go into the 2-6 and again reiterate for the record, Your Honor, this is where, special appearance, and we go back, we made the request, the court denied it, and now he goes, or she goes straight into
Hands
the
down.
2-6.
Okay, hands down. Better to get off before the 2-6, because your client, if he should show up after the 2-6 and notice wasn't present, case law is very clear. All subsequent hearings are void as to him. Remember, the court takes jurisdiction over the child, not over the parent. As soon as the parent makes an appropriate notice or a general appearance or notice is proper within 291, then the court acquires personal jurisdiction, and with in personam jurisdiction, the trial court can then do whatever it wants in terms, well, theoretically within reason, for reunification services or visitation and the like. So what you want to get off the case is, as soon as you give the prospective client an opportunity, you've exhausted whatever remedy you have in terms of contact, get the hell off. You don't belong in the case. You're trying to be a ghost. Leave that to Norton.
What about in the alternative when you actually do contact the client? So you make the special appearance, the Hague notice isn't correct yet, clearly, because you're at the detention or PRC or whatever. You're able to make contact with the client, but you don't believe waiving is going to be in your client's interest. Do you continue to make a special appearance even though you've had contact and just continue to object to notice as a special appearance?
Absolutely. Jennifer Rowe is Lori Fields. I think most of you know Lori Fields is an appellate attorney. She had a case just after mine, just after Vanessa Q. It's called Jennifer O, and it's in this district as well. The issue was what applies. Since the detention hearing can be by oral notice? Does the Hague Convention apply to the detention hearing? And the answer is a simple one. They went through and analyzed the two granddaddy cases. Basically they analyzed Elisa S., which is, the watershed case. It's the BG Hague Convention. And what it said is that the Hague Convention applies up until Vanessa Q. In my case, the law was you could serve in some instances by mail. And so people were sending notices by mail, and the courts were accepting them. That changed, but in Jennifer O, like all ICWA, as I started out by saying, it used to be really easy to get a reversal. Now they've come up with all manner of stuff because they're sick of tying the trial court's hands. They don't want to bog them down. I understand there's some new judges that take all day, and some old ones that follow their lead. So what was, all day to get out of their calendars. Most of you guys are here till 4:30. When are you supposed to do your case reviews and such like? It's, In any event, the point that I was making is that in Jennifer O, they went through that analysis, and they said, well, we're going to start by cutting. This was an interesting thing. You don't need it for a supplemental petition. So if you get a 342, no Hague Convention needs to be followed. A subsequent petition, a 387, no need. So they limited right off the top basically to the juris dispo hearings. Because they're in California bifurcated hearings, we really mean the dispo hearing, because they can't adjudicate the petition on behalf of the child, but if the child is present. If the child is, well, there's a lot of case law, but basically get off the case as soon as you can. Do not worry about subsequent ones. And if you have been appointed and are on special appearance status, your job is to make sure that the court actually orders. Do we have notice? Do we have Hague notice? Is the court finding Hague notice proper? That is not going to the substance of the case, but if on appeal, later on, you want to take this one on appeal, you have no record. You have waived it or forfeited. Someone, I think Emily, you asked about waiver and forfeiture. Just to make it clear, basically, waiver is supposed to be a knowing or at least a voluntary giving up of a right, and forfeiture is failing to raise it below. Almost uniformly, the courts in this district are saying you either waive it or you forfeit it. Because you didn't raise the objection below, you didn't make the special appearance. If you make the special appearance, but you let the department slide on notice, you don't look at the notice to make sure that the notice has the right person's name or even the right address. I mean, you've seen some of these ICWA notices. They're not all that good. Well, it follows logic that the Hague notices aren't a whole lot better. In fact, because they require translated documents, I'd say 99% of the time they're not adequate. And since Mexico has made no reservations that if this is followed, we'll waive this or we'll let this happen, they don't have that. So if you want to avoid a forfeiture argument and have your appeal dismissed, please ask the court. You're not making a general appearance, you're not doing anything except making a record for your client that notice is not proper. You've bought the other parent some additional time. That may or may not be good, and that's something you have to assess. But if you want to protect yourself, that's it. I'm going to turn it over to you for...
Let me just clarify one thing. You'd asked at the 2-6. He's saying get off. If you haven't had contact with your client, I agree. If you're in active communication with your client, you want to be at that 2-6, raise an objection to the notice, and sit down. Look, the bottom line here is, if you're in contact with your client, you can always send him the notice of appeal. You'll type it out, mail it to him. If he mails it back, great, he gets his appeal. He doesn't, it's his choice. But you do want to deal with that, and I would point out, the pitfalls are here, because there is, the Hague Convention really doesn't fit with juvenile court dependency law, the timeline. It just doesn't. It was really designed for something else. And so there's a lot of resentment on the parts of the Court of Appeal towards it. And what Ernesto is really saying is it's a trap. They're setting a trap for the unwary. And just avoid the trap. Once you avoid the trap, your job, most of your job is done. And in fact, it's a lot easier on you because, you know, you're not subpoenaing witnesses and getting ready for an adjudication because your client has not been noticed. One tip that I would suggest, since you're going over to another hearing, very often when there's a Hague notice, it's not attached to your reports. They need to provide you with a copy of that notice, and you have the court order them to do it. Because then you'll examine it. If you get it a couple of days ahead of time, it's even better. You can sit there, examine, pick it apart, make your objection, and then move on. You could even set, see if the court, some courts will allow you to set a progress report or status conference or any, they'll call it any number of other things on the Hague notice. And if it's bad, you just point it out, and then guess what? Move on. All you're doing here is making sure that personal jurisdiction is obtained. Once it's obtained, anywhere under the Hague, everything else, that's the last notice they have to give me, then it all falls on you. Well, make it fall on the department.
Can you ask for courtesy service to the parent?
No.
After that's done?
Oh,
by the
after
department?
they've
Yeah,
done proper.
after
Oh, sure,
in-person,
because they've affected in personam jurisdiction,
Right.
so there's no longer a special appearance.
Right, so when you generally, if you're okay, in future hearings, I want my client served according to what, California law or what?
Yes,
law?
but I would ask for something else. Well, if it's outside the state,
Yeah,
you get a
the
longer
timelines.
period. Yeah, the timeline. But also ask, let's say your client speaks whatever language, ask that the notice be in that language. They can say no, but if the court orders it, that covers you, doesn't it? So you just ask, look, my client speaks Mayan, Tibetan, whatever. He's Tibetan, Your Honor. He lives
No,
in
but if
India.
there's no written no alphabet, how do they do that?
Well, then what I would like,
Oral tradition.
if it's an oral tradition, then Linda, they should send you down, all expense paid vacation to the Yucatan with someone who speaks the language. Take 2 weeks.
One thing that I'm seeing as a possible red flag here is if they're required to translate the document into whatever language it happens to be, let's say for purposes of this example that it's not Spanish or English, something they can easily decipher. Are you, when you're checking notice, I mean, are you obligated to ascertain whether it's an appropriate, I mean, you can't, I'm thinking if it's been translated into a language that I don't know, I can't ever say notice is proper. I can't ever concur because I can't ever say to the court, yes, this was the proper translation
Well,
of these documents.
What I would ask.
Nor can the court really.
But, you know, when we translate documents for court, we usually have a certified interpreter, don't we? With an oath on file or an oath. Maybe they should attach that certificate to it, because I'm going to tell you something. If even in Spanish, if it gets down to Mexico and they're looking at it and they don't like what they're reading, or it's a mess, guess what? You know, they may take it back anyway. So it probably would be a good practice to ask them. Now, there's some countries you don't have to worry about. You have a list of all the countries, by the way, that are involved in this. You know, one I noticed wasn't there was Vatican City, but if they had any children coming out of that, they should. That you'd have to do in Latin.
Let me add,
To get the certificate of interpreter.
let me add that Mexico requires an apostille, which is a stamp. You know, they just love stamps. So you get your interpreter here to stamp it. just like they would if the court ordered it in Spanish. Then there's no question about what it says. It's the same identical for other countries.
And by the way,
So as
we
long as
use,
it's stamped or
Right.
there's a certification
Yeah,
there,
that's-
you're off the hook.
yeah, the other thing is we use the term letters rogatory. People hear that and they think, what the hell is that? A letter rogatory is really a simple thing. It's a request from one judicial officer or court from the assistance for another court. That's all it is. And, you know, if a particular country wants a letter rogatory, then you may be able to, through here, contact them and see what form they want it. Obviously, for our bench officer, it would be in English, you'd have to have a translation. And then they may want an apostille or not, and it's spelled P-I-L-L-E. It's very much close to apostle, but it isn't. And it's just, think of the Stamp Act, you know, from your high school American history lesson. That's all it is, it's just a stamp, it's tax. They get you to pay for it. The other thing that you need to keep in mind is some of these countries charge money for some of the services that go through. That's another reason to leave it on DCFS. Because if there's any expense involved, let the state of California or the county of Los Angeles pay for it. Don't get into the money issue. Any other questions?
I have one question. So after Hague notice requirements are met, you then just make general appearances if you're in contact?
Yeah, there's in personam jurisdiction at that point, full in personam jurisdiction. And so you can argue the merits, and obviously, you know, one of the things to keep in mind, particularly with Mexico, they have a DIF there, that's their social services organization. Other countries may. And particularly if your client wants the child to go to grandma in Guatemala or well, I don't know what Brazil's on here, but there's a lot of conventions they're not part of. You know, the Hague Convention also gives notice to that government. That's another thing in this instance. And if they have their own child welfare authorities and there's a home that's suitable there, it may be better to get the child out of the country. And that is an alternative argument to make to the court, that we're not only giving notice to the individual, but we're also giving notice to the nation state itself. So if these are nationals of that nation state, they can provide for it.
Before I forget, I wanted to give one closing comment. In my experience, the most important thing we can leave you with today is the need to maintain special hearings, because anything else is going to get you in trouble down the line. Maybe not this case, maybe next. And the argument you need to make in the court, if the court wants you to argue about waiver or forfeiture, you can just live straight out of in re Texora H. I think most of us have, that's the case on the seminal case on waiver and forfeiture. It explains that they're basically the identical same thing. We're going to screw you under either doctrine.
And they will.
So it's Dakota H on waiver and forfeiture. I didn't bring a copy, but I'm sure you can find it easily. And I think that you can lift the argument if you have that kind of a case. You know, just keep that in mind.
Just conceptualize this for a moment, and you'll find how easy this is. Service on a central authority or a designated representative. Dual copies unless excused. You have all the regulations and exceptions here, so you know. This will tell you who, that website will tell you who the central authority is for the designated individuals to accept the service. You've got it. It's either there, and it's got to be translated, of course, into official language or some other language designated by the receiving state. It'll tell you if you call the central authority or the consular office. Consular office will tell you. And then you just look at the notice. You're done. You know where you're going with it. This is not hard. It's just paying attention to the detail, that's all. Because you paid attention to the detail, you get 6 more months, you get a year more, and everybody else is having their rights terminated like mad, and you're sitting there, relaxed, in the shade.
Any more questions? We need to wrap it up so that you can wrap up the garbage.
Excuse me.
Yeah, that's my.